at 3.
Okay, lovely. Thanks, Shafiq.
All right.
I see we have a pretty good turnout. I'm very happy with that.
Yes, we sent the invitation to around 100 participants, but we expect more to join.
Perfect. Thank you.
Can you hear me, Manoj?
Yep.
Yes, Terence, I can hear you.
But I think something is wrong with Salina's microphone just now.
Yep. She's trying to rectify that. Shouldn't be long. Thank you.
All right.
Manoj, can you see me? I actually turned on my camera already, but I cannot see myself.
I can see your background, but not you.
Strange.
Okay, so we are now at 3 p.m. So allow me to do some introduction before we proceed with our session. Okay, good afternoon, everyone, and thank you for taking the time to join us today. My name is Shafiq from Group Legal, and also on behalf of Group Legal, I would like to extend a warm welcome to all participants from our stations, the customer relations team, and our colleagues from Legal for joining this session. We truly appreciate your time. For your information, today's webinar will be divided into 2 sessions. For the first session, we are pleased to have Manoj, Terence, and Salina from Client & Co with us to share their insights on passenger claims and liability matters. As many of you may know, there are issues that we encounter quite frequently across different departments, whether it involves delays, baggage issues, denied boarding, or other passenger-related complaints.
Wow.
This situation often requires close coordination between the station teams, customer relations, and legal to ensure they are handled appropriately and consistently. We believe this session will be a useful opportunity for all of us to better understand the legal framework surrounding these matters. By way of introduction, Clyde & Co is a leading international law firm with extensive experience in aviation law, and they regularly advise airlines around the world on passenger claims, liability issues, and regulatory developments. We are very, very grateful that they have agreed to share their insight with us today, and we encourage everyone to take this opportunity to ask questions during the session. Following the first session, we will have a 5-minute break before continuing with our second session, which will cover the perspective of Indian litigation presented by Legal Knights. For this first session, the objective is to provide a clearer understanding of the legal framework governing passenger claims, particularly under Montreal Convention, as well as to highlight certain aviation-specific passenger protection regulation in various jurisdictions that may impact our operation. We hope that today's session will provide practical insights to the participants into how this legal framework apply in real operational scenarios and how we can better manage passenger claims while ensuring compliance with the relevant regulations. So without further ado, I will now hand over the session to our speakers from Clyde & Co.
Right, thank you very much for your kind introduction. My apologies, I think I have a bit of problems with my camera, although I turned it on, but it's still not showing. Anyway, good morning and good afternoon, everyone, and thank you very much for joining us today. First of all, may I say how pleased we are and to have the opportunity to speak with you. I understand many of you are dealing with operational pressures on a daily basis, so we genuinely appreciate you taking the time out to attend this session. As introduced, my name is Terence Liu. I'm a partner at Clyde & Co and am currently based in Singapore, and I lead our aviation insurance, regulatory, and disputes practice across Asia. In practical terms, that means my team and I spend a great deal of our time advising airlines like yourself on exactly the sorts of passenger issues that tend to land on the station manager's desk, often at the most inconvenient moments. For those of you who may not be familiar with us, we are the global law firm with a strong focus on aviation, transport, and insurance. I'll just be very brief, as introduced by your legal team. We have more than 70 offices worldwide, including across Asia, Europe, and the Middle East and the Americas. We act for airlines and insurers, and a significant part of our work involves helping clients navigate passenger claims, major accidents, and regulatory challenges across multiple jurisdictions. The purpose of today's session is a practical one. We are not here to lecture you on legal theory. Instead, we want to walk through the legal frameworks that most commonly come into play when things go wrong, particularly under the Montreal Convention 1999 or the MC99, as will be.
Oh, dia detail lagi lah. Kita tak sampai ke situ, nak cerita pasal Blue Hour.
Or the MC99 as may be referred to by my colleagues later, and under the various consumer protection regimes that are becoming increasingly relevant across the region. We have several offices in Asia, including Thailand, Malaysia, Singapore, Hong Kong, China, and Australia. I'm very pleased to be joined by two of my team members in Asia who will be speaking with me today. First, Selina Yip. I think she's trying to fix her microphone problem. Senior associate based in Hong Kong. Selina has extensive experience handling passenger baggage and accident across Asia Pacific, and she also brings valuable in-house experience from her time advising an airline business operating across the region. Also joining us is Manoj Balani, Senior Associate in our Singapore office. Manoj specializes in aviation disputes and insurance matters, and regularly advises airlines on passenger claims, litigation strategy, and regulatory exposure. In terms of what we will cover today, just by way of brief agenda, we will start with a clear and straightforward overview of when the MC99 applies, who it applies to, and why it matters to you at station labor. We will then look at how liability works in practice for passenger injury, baggage loss or delay, and flight delays, including the updated liability limits that are currently in force. From there, we will turn to aviation-specific consumer protection rules, particularly in Asia, and discuss how these can sometimes sit alongside or on top of the Montreal Convention or your conditions of carriage. Importantly, we're going to make it as interactive as possible. We will also walk through realistic scenarios that reflect the kinds of situations you may face on the ground at station labor, and talk through what the law expects, what practical steps you can take, and when it makes sense to escalate matters to your legal. Our hope is that by the end of this session, you'll feel more confident navigating passenger claims, knowing what legal regime may apply, understanding the relevant limits of liability, if any, and handling difficult situations in a way that protects both the airline and yourself. With that, let's get started. I'll hand over to Manoj and Selina.
Thanks so much, Terence, for that introduction. Good afternoon, everyone. My name is Manoj, and I'm joined by Terence, who you've heard from, as well as Selina. So primarily going forward, what we will try and do is to unpack some of the lead aspects of the legal regimes that apply when you're dealing with passenger claims. We'll try and make it as simple and practical as possible, and hopefully by the end of it, the main takeaway is that you'd be in a better position whenever you're faced with a passenger claim that falls on your table. So what you see in front of you now on the slides are the international routes that MH has around the world. And why I bring up the routes and I identify these jurisdictions that you now see on your page is that in aviation, when you're dealing with passenger liability, for the purposes of standardization across the world, and we know how complicated each legal jurisdiction can be when it comes to their local laws on dealing with claims. So what you had back in the 1920s, very early on, the states had all come together and said, look, we need a regime that standardizes how we deal with passenger claims or passenger liability. And from there was born the Warsaw Convention in 1929. Slowly, that then developed into what you see today as MC99, the Montreal Convention 1999. That is a multilateral treaty which has been quite widely adopted by, at this point, about 140 states plus the European Union, which is another 27 states. So you will see that most of the jurisdictions where MH has a station or operates to or from is covered by the MC99 regime, except for a selective few. What the regime does is that it provides a simple but effective compensatory regime that balances the rights of passengers on the one hand, as well as the carriers on the other hand. When I use the word balance, you will see what I mean when I start unpacking some of the things that you find within the treaty. So let me go on to the next slide on when and whom does it apply to. what you have under the MC99 is that being a multilateral treaty, it is targeted purely in the situation of international carriage of persons, baggage, and cargo. International carriage sounds simple enough as a term, but it can get a bit more complicated, and I'll explain why. What an international carriage means, of course, in simple understanding, is that you would have a flight from one state to another. But how it is in fact assessed as to which international regime is to apply is to look at the entire ticketed itinerary in question. So there are a couple of examples that you see I've put there. What you are to identify is, number one, the place of departure, and number two, the place of destination. So in the case of Kuala Lumpur, Yangon in Myanmar, is the station manager from Myanmar on Teams? Maybe they want to try answering that question.
Yes, feel free to answer if anyone.
So, is the station manager from Myanmar on Teams? Sorry to put the person on the spot. Are they around?
I don't think. So far, I don't think it's around.
No.
Yeah.
Okay, no worries. Maybe then someone who's based in Kuala Lumpur and who wants to try this question that I have. Any volunteers? No, everyone's a bit shy.
I think it's Ramadan lah, Manoj.
Understand. Anyway, Ramadan Kareem to all my friends as well. So let me get straight to it. Okay, when you are dealing with a return flight, for example, from Kuala Lumpur to Yangon, and then 2 weeks later, Yangon back to Kuala Lumpur. The place of departure, of course, is Kuala Lumpur, but because it is a return flight, the place of destination is Kuala Lumpur as well. Okay, so when you break it down, what you have is that whether the MC99 regime applies, because it depends on the place of destination, which in this case is also Kuala Lumpur, which is a signatory to the MC99, that regime applies. But in the event you have a one-way flight, that means a passenger books a one-way flight from Kuala Lumpur to Yangon. In that case, the destination is Yangon, which means that the MC99 will not apply because Myanmar is not a party to the MC99 treaty. Okay. Then one other question we quite often face from our carrier clients is that, but hey, I've got a flight that goes from Kuala Lumpur to Singapore to Hong Kong to Yangon, and then eventually it lands back into Kuala Lumpur. These breaks that you see in the itinerary, they are not relevant in terms of assessing the place of destination. It all depends on what is stated at the point when the passenger contracts with the carrier to buy their ticket. That would identify the initial destination and the initial departure place and the final destination. So moving on, these are two articles. I am not going to bore you all with the language of these articles. That's not the purpose of this presentation. But what is important as a station head is to be alive to this fact that because the treaty is a multilateral treaty that tries to standardize everything across the world for people who have signed up to it, the cause of action whenever a passenger were to bring a claim, that cause of action is exclusive to the convention. So in theory, they cannot bring a cause of action outside the Montreal Convention when it comes to any injuries that they've suffered in the process of their flight, or in terms of flight delay or baggage loss. That is what happens in theory. And in a similar vein, in this Article 26, sometimes you might find whether it is in the conditions of carriage or whether it is in some other form of contractual documents that might be entered into with passengers, you might find some carriers who contract out of the Montreal Convention or provide limits that are lower than what is provided for under the Montreal Convention. And in that situation, typically the legal position tends to be that you cannot contract out of anything that's provided for in the MC99. That provides the minimum base of what passengers are entitled to. Of course, there's nothing stopping a carrier to provide for more than what the convention has. Yeah. So, of course, on the one hand, and this is relevant, I think, to some of the station managers that come maybe working in maybe less predictable or sophisticated countries, right? And that's the reality we see sometimes in less developed countries, where you might have a judicial system that may not fully appreciate what the Montreal Convention may be about, and might then apply their local laws or find causes of action under their local laws. That happens. I will not name countries. I mean, there are examples, but what as a station manager you need to be alive to is that you could find passengers filing claims in court that are outside the Montreal Convention regime. And we'll get to these practical pointers of how you react whenever a passenger claim may come on your table. But since I'm touching on this point of court actions, it's always important when it comes to court actions for, as a station head, to react early and to react quickly. Because what you find across many of these court systems in the countries that y'all are working in now, this concept of if the carrier doesn't appear or the carrier doesn't file a defense in time, it might be taken that you are liable and judgment might be entered against you. And then it becomes very difficult for your legal teams or your insurance teams and even the lawyers eventually to reverse the effects of this. So if you have any indication of a claim that might go to court, or if you're served with any papers, right, or any court papers, escalate it immediately so that actions can be taken to protect amateurs' rights. Now, let me deal with this next part, and it also touches on the issue of courts around the world. So, you as a station head will always be wondering that if a passenger has a claim and they want to bring an action under the MC99 against the carrier, where can they sue, right? And in that sense, it is quite favorable for under the Montreal Convention towards the passenger, because it leaves a number of courts available at their choice. And why this is important is that don't be surprised if you come across a claim that is filed in your jurisdiction, even though it might have involved a flight you had no clue about on a route that had nothing to do with the country that you're operating in. That can happen, right? So there is a case, in fact, I thought it'd be quite interesting to bring up, where you had a situation. There was a flight from Malaysia to Cambodia on a separate Malaysian carrier at that time, And this US plaintiff, your US claimant, she was injured in that flight from Malaysia to Cambodia. And when she went back home to the US, she filed a claim in America. And she said that, well, because I am resident in America, I am entitled to bring this claim here. There's always a tactical reason sometimes why they choose to bring claims in other jurisdictions where they can. But what was pretty helpful in this case is that you had the US courts coming down very strongly to say, no, that is stretching the words of the convention, which requires the claimant to file their claim. Although, yes, at the point of time of the accident where they are resident. So in this place, yes, the lady was resident in America at the time of her accident, but the safeguard is that the carrier must also be operating a service to and from that particular country, and it must conduct business from premises in that country. So we're lucky in that case, at least you had the US courts kicking the case out of court to say that, nope, we will not entertain your claim because you brought it in the wrong court. You can't bring it in the US. Now, the other thing to be alive to when it comes to actions that can be filed under the Montreal Convention, and this might be something where sometimes you have, more often than not, you will have complaints or claims that are made immediate within a week or a month after the incident. But sometimes you might also find claims being made 3 years after the accident. And then you are scratching your head thinking, trying to go back to your records to say when exactly did this happen, and you want to investigate it. This is where the Montreal Convention does help in introducing a limitation period of 2 years, which means that from the point of arrival at the destination, the claimant has to bring their claim within 2 years from that date, right? And more often than not, what we've seen from our survey on the cases around the world is that that limitation period of 2 years tends to be respected by the courts. So this was something Terence had mentioned earlier on the liability, the changing liability limits. You know, when I started off, I mentioned you had the Warsaw Convention. And of course, back in 1929, things were not worth the same as they are today. We have had raging inflation, and in that sense, the liability limits have tried to keep up. So we had the latest revision in December 2024, led by the ICAO, and then adopted by a number of states after that. And so for injury or death, it's up to $210,000 US. Then for delay, it's 8.7, and for baggage loss damage delay, it's 2.1. These are liability limits. And when I say limits, what I mean is that in the first instance, this is the maximum that a passenger may be entitled to. However, at the same time, these are breakable limits. Under certain circumstances, for example, if we are talking about injury, which we'll get into next, if it is shown that the carrier or the accident was caused by the negligence or some other wrongful act of the carrier or its servants, then the passenger might be entitled to claiming higher than this limit, right? Or damages beyond this limit. But otherwise, in a general case where there is an accident and it is not through the fault of the carrier, or it was not caused by entirely by some other third party, then these limits would typically apply. Now, what I'm going to cover now with a bit more, hopefully it's a bit more interesting than the dry introduction I've given, but the dry introduction is important so that you understand when I get into injury and death what I mean. So, under Article 17 of the MC, It covers accidents that occur on board the aircraft in the course of operations of embarking or disembarking. Okay? Accident is a simple word, but let me tell you, it is not that simple when you come to analyzing the facts of a situation. And so this question that I have here, an accident, like I said, could take place on the aircraft in the process of embarkation or disembarkation. And so what I have here is a scenario, an example. And again, if there are volunteers, or maybe I will not disturb any volunteers today unless there's somebody who would love to give their answer to this. So consider this example for a moment, okay? And think about it. You have a passenger who's already checked in, past the boarding gate, past immigration, past the boarding gates, and now their flight has been called. They've been asked to board. They are walking along the aero bridge towards the aircraft. And suddenly there's a shake in the aero bridge. It collapses slightly. Passenger then falls and then injures their ankle. Right? It's outside the aircraft. But the question is this considered an accident? I don't know if I'll get any volunteers, so I'll answer it myself. In this situation, it is an accident, and it's for two reasons, right? The first is that it took place in the process of embarkation. And the second reason is that it was an unexpected event that occurred during that process. Okay? Now let me try and unpack what I mean over here. I'll give you some examples and then we can think about it a bit more. So you have this case. I will not delve into what the case is about from legal terms, but here you have an aircraft with this standard pressurization system, and then the passenger falls sick after the flight from that pressurization system, and then they bring a claim against the carrier. The court rejected that claim, and the simple reason is that because the incident that occurred or the injury that was caused to the passenger was from something that is standard that happens on every aircraft. That's what you would naturally expect in aviation operations. And so that cannot be considered an accident. In that second case, what you had was the passenger was walking along galley, and then they slipped over a plastic strip that was covering the seat tracking slot. And even then, the court said, no, that is not an accident. And the reason is because that is, again, a standard inherent feature that you would find in an aircraft. So let's shift to the other side. What exactly then would an accident be? So an accident is when there is something that is unexpected or that is unusual that happens on board the aircraft or in the process of embarkation or disembarkation. Let me give you some examples. You have severe turbulence on a flight. Then you have a passenger getting injured as a result. Is that an accident? Most of the time, yes, it is. Right? It is agnostic to the question of fault, which means that it doesn't look at as to whether the carrier was at fault or not. As long as there was an unexpected event that happened on the aircraft, for the purposes of defining the word accident, it would be considered as one, right? The reason I bring up turbulence is that because y'all would have come across a number of recent incidents. In fact, turbulence is now a topic that I think we could spend another 2 hours talking about with the amount of case law and incidents that have happened recently. But we are seeing it happen more and more these days because of the air pockets around. And what you have here is people suffering from injuries during an accident. And then it raises the question of, does an injury suffered during turbulence, is that considered an accident, right? And how some of the courts have approached it is that they've looked at the severity of the situation or the severity of the turbulence. In cases where the turbulence is light, then courts have seen it more as, well, that is the expected in the normal operation of an aircraft. And so we wouldn't consider that an accident. But in cases where the turbulence has been severe, those cases, we've seen a trend for the courts these days to find that that would consider or that would be considered an accident, right? Now, to give you a little bit, a few more examples, things y'all would probably have seen numerous times in terms of claims being made by passengers. One of the most popular ones we've seen is cabin baggage falling from the overhead bins. And here, always sit back as a station head and analyze the facts and ask yourself, what happened, right? If you have a cabin bag that falls from the overhead bins on a passenger, is that something that normally happens? No. So would that be considered an accident? Most of the time, yes, right? Then even things like as mundane as the behavior of other passengers, where there would be the spilling of drinks, you have some intoxicated passengers falling on another passenger and injuring them. These are examples of cases where the courts have found them to constitute accidents, and therefore giving the passenger the right to claim for compensation under the regime. So this is another example where you had of a ram vehicle colliding into the aerostairs before the aircraft had taken off. And the question there is, if a passenger is stepping along the stairs and then loses his or her balance because of this ground vehicle knocking into the stairs, does that constitute an accident if the passenger gets injured from it, right? And in this case, yes, again, because this kind of incident is something that is unexpected and that is external. And you wouldn't usually expect that a ground handling vehicle would knock into a flight of stairs. Now, there's a separate question some of you may already be thinking about. Yeah, but, well, it's not the carrier's fault. It's the ground handler's fault. For the purposes of liability, it is still typically seen as the carrier's liability, but that doesn't mean that the carrier cannot then attempt to look for recovery against the ground handler. And that's a separate question. Now, what type of bodily injuries are covered? This is more or less straightforward, at least for our purposes in this presentation. You would have your standard physical injuries up to death, but where things have got a bit muddy and I am fairly certain that each of you would have faced complaints of emotional passengers coming to your desk or writing a claim that I am emotionally distressed, I've suffered PTSD, I can't recover from the adverse effects. And look, sometimes some of these complaints may be genuine and they must be respected, because psychological injury could be caused. But of course, we have to then sift that out from the exaggerated or the made up claims of passengers coming to you with their emotional distress. And the courts around the world, and I've looked at, or we've looked at cases in the US, in the EU, and then there are some other cases that are emerging. There's no real consistent thread as to how they treat psychological injuries, but what you see is that there must at least be some causative effect. between the accident and the mental injury that was suffered as a result. But in some cases, less than that is enough. So let's go on to this question then of, when I was talking about turbulence, I believe the thing that must have popped up in your heads was the seatbelt sign. Well, pilots are sometimes able to foresee from their instrumentation that there might be turbulence coming up, and they would have their seatbelt signs put on for passengers to comply with. And then this brings us into another question when it comes to liability. What we were just talking about was the carrier's fault. But in some instances, the accident happens because of the actions of the passengers. They caused their own accident. For example, they are adjusting their cabin bag and then their cabin bag drops on their own head, right? Or in other instances, you have the seatbelt signs on in the situation of a case of a turbulence, and the passenger just refuses to comply and starts walking around and then suffers injuries as a result, right? This brings the concept of contributory negligence. So the convention also appreciates that in certain situations, you could have a case where the passenger may be at fault for whatever they've suffered, maybe not entirely, but partly at fault for whatever they've suffered. And I was just working with Terence on a case recently where we were dealing with the question of a seatbelt sign on a different carrier, and this particular flight had suffered quite severe turbulence, and this lady had suffered an injury as a result. And then when we had the claim being put forward, the first question when it came to us investigating and looking into the facts is that at first we thought the seatbelt signs were on at the time the turbulence occurred, and this lady, of course, the fact that her head was injured clearly hadn't worn her seatbelt, right? But after digging a little bit more, we found out that the seatbelt signs had only come on 3 seconds before the turbulence. Now, then that's a different question, right? Can you blame the claimant for not having her seatbelt sign on? In other words, did she have enough sufficient reaction time as soon as the seatbelt signs came on in order to put it on to avoid the injury? Probably not in that situation. So why I bring this example up is that because as station heads, what you would see is that sometimes you act as the point of contact when it comes to maybe gathering evidence from the other stakeholders as to what exactly happened in the course of an incident, maybe in response to a passenger claim or complaint that has been made. And in that situation, what you want to be doing is to try and collect facts as objectively and as thorough as possible. Because sometimes facts that may seem mundane are fairly relevant to how we analyze liability. So that concludes my section on injury and death under the Montreal Convention, and I pass it on to my colleague Selina, who will take over from here.
Hello, can you hear me well? Okay, I presume no problem then. Okay, so in this section, we are going to look at some typical baggage claims, okay? I'm sure you as station managers have come across different types of baggage claims, okay? Some can be very emotional. You know, in my career, I have come across baggage claims concerning medicine. Passengers have no access to medicine upon arrival because the baggage is missing or because of the baggage is delayed. And I've also come across very emotional situations like, the lost baggage contains human remains. Well, in this case, how are we going to compensate the passengers? And I've also come across instances where passengers, they put their negotiable papers, their contracts, in their checked baggage, and the checked baggage is delayed or missing upon arrival, and so they claim that, oh, they have lost a significant business opportunity. Now, so, but in this section, I'm not going to burden you with case law or with legal literature concerning, baggage claims. Okay, what I aim to do is that I want to raise your awareness of the airline's potential legal exposure with regard to baggage claims, so that you can deal with passengers more sensibly when they have a baggage issue. Certainly it can be very frustrating for the passengers. They can't find their bag. But what I've come across is that if the station managers or if the airline staffs on the point of arrival give immediate assistance to the passenger, for example, arranging transportation for them, giving them like cash vouchers so that they can purchase their necessities for the trip, that can help de-escalate claim. And I've also seen cases where station managers, they give regular updates to the passenger with regard to the tracing of their bag. That also gives the passenger an assurance that, okay, the airline is actively helping me locate my bag. That would give a sense of comfort to the passenger, and so that also helps de-escalate claim. On the other hand, I've also come across instances where, no updates were given to passenger, and the passenger was, completely mad at the airline's handling of their claims, and so the passengers went to court to pursue a damages claim against the airline, even though the damages could just be nominal. The passengers also went to regulators with regard to their baggage. So without further ado, okay, so today we're going to focus on some typical baggage claims. They are lost baggage, loss of baggage, the bag never arrives. And you have also seen baggage damage, okay? Damage to the contents of the baggage or damage to the suitcase itself. And sometimes we come across partial loss of the baggage in cases of, for example, theft or pilferage. Delay is where the bag arrives later or never departs at the point of departure. So let's look at what the convention says. Okay, Article 17 of the Montreal Convention provides that carrier is liable for destruction or loss or damage to checked baggage on board the aircraft or while it is in the charge of the carrier. In other words, okay, as long as the baggage is in the custody of the carrier, in the charge of the carrier, even though the carrier has no fault with regard to the loss or the damage to the checked baggage, the carrier is presumed liable. Now, we have to note that there are distinctions in the liability regime between checked baggage and unchecked baggage. In cases of checked baggage, carrier is presumed liable for any damage, destruction, or loss or delayed, okay, while the checked baggage is in the custody of the carrier, subject to certain defenses, which I will cover in due course. But for unchecked baggage, okay, carry-on bags, cabin baggage, the carrier is only liable if the damage is resulted from fault of the carrier. In other words, it's a fault-based regime, okay? But we have to also note that in certain cases, cabin baggage, carry-on baggage can also become checked baggage when, for example, due to lack of space in the overhead compartment, the airline staff or the cabin crew require the passengers to check in the carry-on bag, or the baggage is handed over the crew whilst in the aircraft, or the place or the manner in which the baggage is stored in the aircraft during the flight makes it impossible for the passenger to have access to it. Now, these defenses are applicable in cases of a baggage claim. For example, there is this inherent defect of the baggage, quality or vice of the baggage, or there is contributory negligence. The baggage is not locked by the passenger, or the passenger fails to give timely notification of their loss or of the delay. Okay, and the limit of liability is currently around 2,100 USD. Okay, for both checked and unchecked baggage. The limit is breakable if there is any special declaration of interest, or the passenger can show that the airline acted with intent or recklessness, that the knowledge to the damage would occur and the airline still failed to prevent it. Now, I would like to give an interesting example. In the past, when I worked with another carrier in Asia, I came across a lot of claims concerning a particular suitcase brand. Okay, very often that suitcase the suitcases produced by that factory, by that brand, were very susceptible to damage, very susceptible to dents or scratches, and so the carrier received a lot of claims, okay, arising from that baggage brand, from that suitcase brand. But one day we found on the brand's website that, okay, we encourage our customers to embrace the dents and the scratches because they are unique patina of your travel. They make your baggage personal, and they make they provide you with a good recollection of your travel journey. Now, with that statement on the suitcase factory website or the suitcase brand website, we managed to turn down a lot of claims, concerning baggage damage for that carrier. So this is something that perhaps you can, bear in mind. And another point to note is the recoverable losses. I've come across station managers thinking that, when it comes to baggage, there is this liability limit of approximately 2010 US dollars. So for every single claim, they pay their customers, they pay their passengers up to the liability limit of 2010 USD. What I would like to remind you all is that this liability limit is not an automatic entitlement, okay? The passengers still have a burden of proving their loss, okay? For example, they still have to produce receipts or pictures of their contents of their bag in order to prove their losses, okay? So even though there is this liability limit, that is not an automatic entitlement, okay? The passengers can only recover the losses that they are able to prove. So that's the general rule. Another point is that very usually when it comes to like baggage delay, okay, if the passenger claims that, I have to spend money on clothing for my meeting the next day, or I have to spend money purchasing medicines that I need, these expenses, insofar as they're reasonable, are usually recoverable, in case of baggage loss or baggage delay. Okay, so let's look at delay now. Article 19 of the convention says the carrier is liable for damage occasioned by delay in the carriage of air, of passenger, baggage, or cargo. Now, I would like to ask you, do you think that whenever there is a delay, okay, the airline is liable for losses occasioned by the passenger? I would like to give you some tips here. There are some defenses applicable to the carrier, applicable to the airline. For example, the airline has taken reasonable measures to avoid the damage, or it's impossible to take such measures. So with these available defenses in mind, do you think that, okay, for example, there is a delay caused by typhoon or caused by earthquake, okay? It is not possible to avoid the flight delay, okay, because earthquake is something that nobody perhaps could predict, and you can't take all reasonable measures to avoid the earthquake. But is the carrier automatically liable in this case? No volunteers? Okay, no worries. Anybody? No? Okay, no worries. So I would like to highlight here that when there is a delay, okay, and if it is not possible to avoid the delay, it doesn't mean that the carrier is automatically liable. We have to pay attention to the wording here. The wording here is that the carrier, the defenses, okay, the carrier has taken reasonable measures to avoid the damage occasioned by the delay. So for example, when there is a typhoon, when there is inclement weather, okay, causing the flight delay. Okay, so that part is not avoidable. But has the airline taken reasonable measures to avoid damage caused to the passenger occasioned by the delay? For example, is it possible for the airline to arrange hotel accommodation, to arrange food and beverages for the passengers, to arrange communication facilities for the passengers? Is it possible for the airline to do that? Has the airline done that? Okay, if it's possible for the airline to do that, and if the airline hasn't done so, then arguably the airline has failed to take all the reasonable measures to avoid the damage occasioned by the delay. So I hope I have made that point clear, but if it's not, then feel free to raise questions. Okay, so when it comes to limits of liability, for flight delay, the limit currently is around 8,700. For baggage delay, is also around 2,010. Okay, again, the limit is breakable in certain circumstances. So I hope that is clear. Another point to note, is not written on the slides, is that as station managers, okay, you may have certain settlement authority to settle claims or baggage claims on the spot. Okay. Whenever you settle a claim, remember to always have a release and discharge signed and returned to you by the passenger, because that way you can prevent the passenger from bringing another claim to the airline. And it's also very important when dealing with very emotional passengers, for example, that you do not admit fault. Okay, so yes, even though the convention says yes, the airline is presumed liable, blah blah blah, and you may feel that the defenses do not apply, don't immediately admit liability without consulting your legal team or your insurers. Okay, try not to do that. Try to deal with the passengers in an apologetic way. There may be a danger in making apologies. In some jurisdictions like Hong Kong, where I'm based in, we have this apology law stating that an apology does not amount to an admission of liability. However, I'm aware that in certain other jurisdictions, you may not have such a legislation in place. So if you want to perhaps de-escalate claims, or you want to calm the passengers down, perhaps say something like, I'm very sorry that you feel that our service was not up to your standard, or you say, I'm very sorry that you feel that your journey was not a pleasant one. What can I do to help you? What can I do to assist you? How can I make you feel better? So I hope the tips given here can help you deal with baggage claims that you encounter on a day-to-day basis. Is there a question?
Yes, Salina, we have two questions here.
Yes.
First one, I think, coming from Station Head Singapore, asking on to explain further on force majeure, I think because of the flight delay and also baggage delay. And the second question coming from Station Head Xiamen, China, which in the chat box, for carry-on baggage which has to be stored to cargo compartment due cabin space limitation and so on, we usually give arrival station notice not to open the claim on entertainment for the passenger. Is it the correct way legally? So
You mean not to open a claim for the passenger when they have a baggage issue on the spot upon arrival?
I think that is the intention behind this question. Yes, correct. Yep.
Okay. So in my experience, we certainly wouldn't encourage passengers to make a claim. We don't want to do anything to invite the passengers to claim against the airlines or the airlines insurers. Okay, however, passengers these days can be very litigious. I've come across passengers in China, in India. They are becoming more and more aware of their passenger rights. Okay, they like to, go to the court straight just for a very small amount of claim. Sometimes they go to the Consumer Protection Authority, and sometimes, in this day and age, they complain on social media. So I think as an airline, you have to consider all these possibilities. Okay, if the customer or if the passenger is going to make a fuss on social media, is that going to affect your reputation? Is this something your management would be concerned about? So I would say in relation to the second question, I wouldn't do something to encourage the passenger to make a claim, but I would try to make the passenger feel that he or she is looked after, that as an airline, we are trying our best to assist the passenger, or to, sometimes it can be a very simple gesture. It could be, oh, your bag is damaged. I have a tape here. I'll help you, tape your bag, your suitcase, so that you can go back home without much difficulty. Or I will call a taxi for you, or I'll send you to the underground station. Some simple gestures like this can help de-escalate matters. I hope I have answered your question. If not, let me know. Is there anything you would like me to supplement on the second question?
I think the second question rather more to we advise the arrival station. That means the station the passenger arrive for the ground handler not to entertain any claims. Is it correctly done? That's a question, actually.
Yeah, not to entertain, it may be a matter of your airline's policy. Okay, so the ground handler, they may not have sufficient authority to represent Malaysia Airlines. In this case, then yes, do not entertain any claims. Or you can simply tell them, oh, if you have any comments, any questions, then please, ring our hotline and then give them your airline's hotline to the passenger, or you may send an email to our customer care team, etc., etc. So that way, you can avoid handling the claim upfront. On the other hand, the passenger can feel that, okay, the airline is not simply, shifting responsibility, avoiding responsibility. The airline will do its best to handle the situation, and the airline has referred me to the responsible personnel or the responsible department.
Manoj, you want to say something?
No, nothing.
I'll just jump in very quickly. Thanks, Selina, and thank you for the question. I think apart from what Selina has shared, I think we may take this is in relation to the question from Yan. We can perhaps take a step back to look at the legal regime. I think Manoj has shared the position under the Montreal Convention 1999, whether an accident can be established. That will determine the carrier's liability. And obviously, in a situation as outlined by Yan, due to space constraint, you ask the passengers not to open the overhead compartment because you have to store all the unchecked belongings or baggage there. And in the unlikely event someone just opened and caused an injury or incident or accident, because of that notice, potentially, depending on the jurisdictions involved, they may amount to contributory negligence on the part of that particular passengers. It depends, though. If, let's say, passenger A opened the compartment despite the formal notice and causing damage to passenger B, who is unfortunately sitting underneath the overhead compartment, but passenger B does not open the overhead compartment, that may amount to an accident insofar as a claim by passenger B is concerned. The contributory negligence point defense may not be available in relation to a claim by passenger B, but in relation to potential injury claim from passenger A, that potential defense may be feasible. It may sound a bit complex, but it depending on the situation. So this is the legal regime as to how best you want to deal with this, because technically your legal liability is governed by the relevant regimes convention or your contracts, or maybe specific consumer protections that will be touched upon later. The passengers technically still can bring a claim against you if you ask your ground handler not entertain the claim, depending on the jurisdictions, as I mentioned. Obviously, as Alias mentioned, we don't want to invite claims against carrier, but if a passenger has up to 2 years, if the Montreal Convention is applicable to pursue the claim against carrier, if in the early stages after an incident has happened, the claim is not properly dealt with, that may potentially cause some problems, because the passengers might be provoked or may feel that the claim has not been properly dealt with, and may pursue his or her claim formally by appointing a law firm to do so. So given the time constraint, I think I tried to summarize these various possibilities. I hope that address some of your questions broadly, but happy to take it offline in you have any specific queries arising from what we just shared.
Yep, I think that is. I think Yan Yan, can you agree with the explanation given, or do you have any follow-up question based on the explanation given? I think they already summarized everything, also give you another view to cover in the event there is accident happen for this situation. If
Thank you.
Yeah.
And for Mr. Mohammed, the Singapore station head, I note your first question in relation to force majeure. So sometimes in contract drafting, it's up to the drafter of the draftman of the contract to define it, okay, to define what events fall into the meaning of force majeure, okay. You can include up to, if the parties agree, they can include as many events as they want to, as a force majeure event. But absent that definition, very often would say, if an event is unforeseeable, uncontrollable, and, for example, like natural disasters or acts of God, that would be force majeure. But then in the context of baggage claim, okay, that concept may not be so relevant, because all we are talking about is, okay, is there delay of the bag? Is there damage to the bag? Has the airline taken all reasonable measures to avoid the delay or the damage? If not, then the airline has a liability. The defense does, is not applicable to the airline. So ask yourself this question. Okay, there may be a force majeure event. Okay, there may be war. There may be security issues which caused the flight to delay. Okay, the flight simply cannot take off because of a government order. But has the airline taken reasonable steps to avoid damage to the passenger occasioned by the delay, i.e. has the airline arranged, for example, hotel accommodations to passengers? Has the airline arranged food or communications channels, facilities to the passenger? So I think these are relevant considerations. I hope I have addressed your question. Otherwise, we can discuss it offline. More than happy to, have an other chat about this offline, because I'm conscious of time. So over to Monash on the next one.
Thanks so much, Alina. That was great. Very clear on baggage. And what we go into next is something, what we've been looking at so far is the Montreal Convention regime. And that's a macro international regime that applies to all the states that have signed up to it. But what has happened now, and has been a trend, is that many of these individual countries have been passing regulations for the purposes of aviation consumer protection. And you in your stations would have seen that in some of your countries that these regulations have been passed. And I think one could say that what really set the matter in motion was the EC 261 in 2004, where you had these regulations being passed to create one would argue a separate compensation regime whenever there's flight disruption that affects delay, cancellation, overbooking, sometimes even on matters relating to baggage. And one of the questions that had come up very early on was, is this overlapping with MC99? Does it subsume some of the things in MC99, or is it a separate regime? It's been clarified that the intention of it is that it operates as a separate regime. So these consumer protection regulations in the countries are separate from what you see in MC99. But sometimes, in theory, it is separate, but in practice, it may not be so easy to separate the two. And you will understand what I mean when we go through some of the situations. And of course, we don't have very much time to cover the regulations in all the states, and something I was talking to Ain about before the presentation. We thought to try and select some of those states that are maybe most relevant to what happens for some of you. Okay. So as we go along and cover each of these states, we've come up with a scenario, like an example situation that you're faced with. For example, where your station airport has a flight that is scheduled to depart at 11 p.m. that night to Kuala Lumpur, and there's a technical defect that the aircraft has, and it's identified. Passengers are at the airport waiting for the flight, and the repairs are going to take around 4 to 5 hours before it can be cleared for flying. You, as a station manager on duty, putting aside the passengers who are beating their chests and protesting over the delay, you're also going to be considering as to what are your obligations in that station. What do you have to provide these passengers while there's a delay, right? And we'll try and look at this same example across the different regimes that we see. So let me start off with India, right? MH has a number of cities in India that it travels to, like Kolkata, Amritsar, Delhi, Hyderabad. And India is a bit like, to explain it this way, it is complicated because what you have is that you have regulations that are spread across different laws. You have, on the one hand, the MC99 that applies. What you also have from the consumer aviation protection side is the civil aviation requirements that were passed by the DGCA, the Directorate General of Civil Aviation, which is India's aviation regulator. That applies to flights that are both to or from India, operated by foreign carriers. Then on the third side, or the third column, you have possible claims being brought by passengers under their General Consumer Protection Act. And to put it very simply, this act is to protect consumers who buy goods and services in the market, and it's been interpreted to cover aviation services and goods. So you could have a passenger filing a claim under the Consumer Protection Act against the carrier for maybe a deficiency in service, all right? And then on the fourth column is you could find passengers taking up general claims against a carrier, whether it is for the breach under the conditions of carriage, whether it's under contract or under tort. And then that puts you in the whole general litigation system in India. I know that there's an Indian lawyer who would be speaking more about the litigation system. Listen to him or her, because it will be quite interesting. There are a lot of facets of it that we may not be very used to in some of the other countries, in terms of how long cases can take before the courts. I think there are some records that may have been beaten. You're talking about decades before you can have a case resolved with a final judgment. So what my focus here is today is on the aviation consumer protection that applies to foreign carriers. And what I can do for the Indian station heads is that if after this you send me an email, I can direct you to some of the resources that are out there, put out by the DGCA. You have the regulations itself, which may be a little more tricky to interpret because they are more legalistic. Then you also have the regulations being put out in an infographic meant for passengers, and something I can refer you all to try and understand it. When you go through these regulations, you will see that there is a fixed compensation and fixed obligations that apply to carriers in the situation of a delay, a flight disruption, or flight cancellation. And actually, I think Rosmadi had asked this question on force majeure, which Selina answered. And that's a very good question, because force majeure, and let's not use the word force majeure. Force majeure is a Latin term. The simple translation of it is extraordinary circumstances, right? What you will find in many of these consumer protection regulations we will go through is there is a recognition by the regulator that there are some situations which are entirely outside the control of a carrier, right? And what the regulations call them, force majeure or extraordinary circumstances. For example, political instability, a riot, natural disaster, war, flood, explosion, government regulations, maybe air traffic control issues, weather issues, security risks. These tend to be defined as things that are outside the control of a carrier. And that would then qualify as a situation of extraordinary circumstances, okay? But it is not that generous under some regulations, and I'll tell you a bit on, we've not covered this here, but I'll give you an example since you brought up force majeure. In the EU, for example, when you interpret extraordinary circumstances, it doesn't include any activities or incidents that are expected in the ordinary course of an aviation operation of a carrier. What that means is that if you have a delay because of some technical issue in the aircraft, most of the time that is not considered an extraordinary circumstance. It is expected that you might have such issues, and therefore it is the obligation of the carrier to prepare for it in advance, right? Now, using the scenario that I brought up at the start of this 5-hour delay. So in India, in the consumer protection regulations there, you would have at a minimum, if it's a short delay or for certain block time of flights, you're talking about a minimum of having to provide meals and refreshments, right? But when the delay extends to beyond 6 hours, and that particular flight is scheduled to depart between 8 p.m. and 3 a.m. The carrier is then obliged to provide passengers with facilities such as hotel accommodation and transfers when necessary. So, as a local station head, familiarize yourself with the nuances of these regulations so that you don't fall foul of them we've had to deal with incidents before of regulators bringing up these issues to the carrier directly asking, is your station head not aware that we have these regulations out there, and this must be respected? I know it is stressful, of course, in some situations when you have an entire flight delay, having to deal with that many passengers, but that is the nature of these regulations and what is expected. Then in the separate regime I was talking about, you have the Consumer Protection Act. That is something where we've seen personally a number of cases now being filed under the Consumer Protection Act. And what our thoughts are on that is, it seems like it is easier to file or practically more convenient to file it under the Consumer Protection Act, for the simple reason that the compensatory limits are different. It is not very prescribed like the case of the Civil Aviation Requirements Regulations. So there is a possibility that you as a station head may then be faced with claims under the Consumer Protection Act as well. And you could have claims being made for things like damages, refunds, costs, even punitive compensation in some cases. So I'll pass the mic back to Salina to deal. Yeah.
Sorry to interrupt, Manoj. I think there is a query from Emil. I think you want to deal with that one. You touched on the.
Sorry, I missed that.
We can go back to slide number 7. So the question
yes,
is, does MH apply MC99 or the Warsaw Convention when handling passenger claims?
Yes, so I saw. So thanks for bringing that up. So it goes back to the analysis, right, of what is the place of departure and what is the place of destination. In most states, because they are signatories to the Montreal Convention, then I suppose MH would be applying the Montreal Convention, in addition to some of these consumer protection regulations I've been talking about, right? But the Warsaw Convention would be rare in terms of its applicability. And one example there was Myanmar. If you have a one-way flight to Myanmar, then you go by the lowest common denominator, which would then be the Warsaw Convention. So I'll leave my colleague Salina to deal with the next couple of slides.
So the question then is, what if it's ex-India to the varied destination? So the responses is still, you still have to look at the full ticketed itinerary. So we have summarized in slide number 7, the routes, the destinations of MH currently operating to, currently flying to. And you'll see in our summary that out of all these destinations, only Taiwan and Myanmar are not signatory to MC99. So, for example, if a flight is from Singapore to, let's say New Zealand, okay, if it's a return journey, then the MC99 would apply. And if it's a one-way journey, for example, from Sri Lanka to South Korea, again, the MC99 will apply. What if it's a one-way journey from Singapore to Myanmar? In that case, as Manoj has pointed out, we go by the lowest denominator. In that case, the Warsaw Convention would apply because Myanmar is a signatory and has adopted the Warsaw Convention, but it is still not a signatory to MC99. And so, according to the rule earlier set out, we go by the lowest denominator. Warsaw Convention would apply. But if, for example, the full ticketed itinerary is, let's say, Kuala Lumpur to Myanmar, and then to Sri Lanka, and then back to Kuala Lumpur, in that case, you look at the place of departure, that is Kuala Lumpur, and the place of destination, Kuala Lumpur as well. And in that case, MC99 will apply. Have I answered your question? Have I addressed your question? Is that all clear? For example, if the flight is from India to Myanmar one way, then that would be Warsaw. But if it's a return ticket, okay, India, Myanmar, India, then it will be MC99. Okay, so let's go back to the consumer protection bit. So in our earlier example, you see that there is a flight delay. Okay, the STD was 11 o'clock in the evening, and we know that the delay would be at least 4 to 5 hours, according to the airline's maintenance team, technical team. In this situation, I'm sure the colleagues in China would be aware of the provisions on the administration of flight regularity that's implemented in January 2017. It's the primary regulation in China governing flight delays and cancellations. It applies to domestic as well as overseas foreign carriers operating flights from China or stopping in China. So in that regulation, okay, delay is defined as you having a departure time that is 50 minutes or more than the scheduled departure time. And a cancelled flight is defined as a flight that is not operated, okay, due to delay or anticipation of delay. Now, the airline obligations would depend on whether the delay or cancellation is attributable to the airline, okay? For example, if there is an engine defect, then very likely it will be causing delay. Then very likely the delay would be for a reason attributable to the airline. And in this case, the provision stipulates that the airline must provide at the airline's own cost food and accommodation to the passenger. So if it's like, if the delay is going to be overnight, you will have to provide for accommodation or even perhaps like hotel shuttle to the passengers. Now, if the delay is not attributable to the airline, for example, suddenly there is this adverse weather making it not safe to fly, then the airline still has to make arrangements for food and accommodation to the passengers, but the cost would be borne by the passengers. And it's also noteworthy that under the provisions, you have a notification of duty to the passengers. You have to notify passengers of any flight status changes within 30 minutes after becoming aware of the changes. Okay, so now let's move on to the next jurisdiction, Thailand. Thailand is quite similar for all Thai as well as foreign carriers. So domestic carriers and foreign carriers, if you have a flight departing from Thailand, then the following applies to you. If the delay is more than 2 hours, then you have to provide free food and beverage or food voucher, as well as access to communications to passengers. If the delay is 5 hours or more, then you have to provide anything stated above, plus hotel, refund if the passenger chooses not to travel, and cash compensation that is around USD $50 or equivalent vouchers or miles. And if it's a delay for more than 10 hours, then the above would apply, plus you have to provide distance-based compensation, okay, ranging from approximately $65 US to $150 US. Again, if the delay or cancellation is caused by extraordinary circumstances, okay, then carrier, Malaysian Airline, would not be required to pay cash compensation. However, the regulations suggest that you still have to provide care for the passenger. It's just that you don't have to provide monetary compensation, but you still have an obligation to look after the passenger and to provide them with assistance. So the next jurisdiction, I'm going to hand over to Monash to talk about the Philippines.
Thanks, Alina. So with the Philippines, what we have is the Civil Aeronautics Board together with the Ministry of Transport, and they took the initiative back in 2012 to pass this Air Passenger Bill of Rights. Again, the similarities you will see across these various different consumer protection regulations is that they tend to deal with cases of flight disruption. They tend to provide some form of fixed compensation, right? And they also tend to deal with situations of extraordinary circumstances. So in the case with the Air Passenger Bill of Rights in the Philippines, that's been amended, I think as recently as last year, it deals with international flights that depart from the Philippines out, and they have a regime for compensation and obligations for delays, cancellations, downgrading, lost, delayed, or damaged baggage. Again, for the station head that might be based in Manila or in the Philippines, let me know. I will direct you to this CAB's summary of rights, which I thought was quite helpful in the way they put it into a nice pictograph and illustrated when or what the obligations and how a carrier should react in a particular situation, right? When you go through the regulations, take a stab at it. I encourage you to read it in your own countries. I appreciate that sometimes it might be quite confusing and technical, but go through it, and sometimes you might find resources out there that might helpfully summarize some of these things. Or of course, we are there to help on that as well. And to use that example of a 5-hour delay earlier in the Philippines, it depends on whether the delay has been caused by a situation of extraordinary circumstances or whether it was for some other reason that may well be the fault of the carrier. And if it's a delay that is beyond 4 hours, the regime in the Philippines is quite passenger-centric, giving the passenger the right to even ask that the flight be treated as cancelled for them, and they'd be entitled to a refund in that situation. Or rebooking or a replacement flight. They could even avail themselves to other alternative modes of transport. And if the cancellation was done less than 24 hours prior to the scheduled time, but it was not in the control of the carrier, then the carrier only needs to help the passenger navigate and book a hotel. It doesn't have to book the hotel for them and pay for it. It just needs to help them with it. Whereas if the fault or the delay is on the part of the carrier, then the carrier has the duty to provide for hotel or alternative transport. Now, the last one that we're covering is more to just for completeness. I thought to highlight Australia to some of the station heads that are here. Australia is now in the process of coming up with their own set of aviation consumer protection regulations, and it's already in that consultation phase with parliamentary debates over it, and we are expecting the regulator to pass these regulations sometime in the course of this year, which might be quite soon. And again, I think you can expect that you would have a charter of rights for what the passengers are entitled to. And interestingly, in Australia, they're also coming up with a scheme, a consumer ombud scheme. Essentially, ombud scheme is where you have the regulator playing the role of either a mediator between two parties, the passenger and the carrier, or in some cases even as a decision maker, like sort of a tribunal, right? But again, it's to be seen what kind of scheme exactly they introduce in Australia. So watch out for that. And we go on to our last slide to kind of draw everything together from some of the things that we've said and conclude with a few practical pointers that you can take back with you, right, when you are in the process of carrying out your role and dealing with passenger claims. So the first thing is that do your best to be as familiar as you can with whatever local laws and regulations there are, as well as the convention. because at the end of the day, you are going to be the face of MH at these stations. You are the extension of MH, and you are the face that deals with the regulators, the passengers, and stakeholders. So put legal at one side, reputation is also very, very important in this industry. And if you show that familiarity with your obligations as a carrier and you treat the passengers with that same knowledge, I think that would be appreciated and respected. And you would also be in compliance with the laws. So the next point on the conditions of carriage, Selina will deal
point
with.
is that
Yeah.
you have to be familiar with the airline's internal policy, your internal SOP, standard operating procedures, or internal protocol on how to deal with certain situations. Yes, as Manoj has rightly pointed out, aviation is a heavily regulated industry. You have to be familiar with the laws, with the conventions, with the consumer protection regimes, yes. But, when there is a flight delay or an unexpected situation, okay, a station heads, the situation may be chaotic and you will have lots of customers coming up to you for assistance. At that time, it might be, it might be helpful if you're familiar with your own internal protocol on how to address situations, so that as an airline, you deal with situations with consistencies. There may be different station heads on duty on different days, but if you adhere to your internal protocol, then you can ensure that passengers are treated with consistency and fairly. And the third point, over to Manoj.
Yeah. So we'll be alternating the points here. So you'll hear from both of us. And this one deals with how you approach passengers. I'm preaching to the choir. You all know this better than I do, that when you're dealing with these complaints or claims, you want to deal them with efficiency, but at the same time, because the emotions tend to run very high, and you might face some very unreasonable and rude passengers in your work, the idea is to try and look past that, deal with it diplomatically and with due sensitivity as well, right? Keep calm, be polite and sensitive about the situation ahead of you. And sometimes passengers simply just want to be heard. And then that's the exercise of your soft skills in the process of how you navigate it and bring up, and in some cases escalate these claims.
Yeah, and the fourth point is record keeping and evidence preservation. So when dealing with the passengers, okay, or when settling claims with them, or when handling complaints from passenger, it's very important that you record what led up to the claim, what led up to the complaint, okay, so that when you pass the file later on to another department, for example, to your legal department or for your insurers to handle, they will have a complete picture of the case. They will have as much relevant information as possible to handle the situation. And, if you do pay out compensation to passengers, if you do settle claims with passengers, make sure that you record it, and the passenger also signs a piece of paper to acknowledge receipt, and if applicable, the passenger documents that they give up their right to make another claim against the airline in the future arising from the same incident. So this, the record keeping part is very important, especially if the passenger chooses to pursue the airline further at the court or at the regulator, that will prove what the airline has done to settle the claims or to handle the customer's situation sensibly.
Yeah. I thought I'd just deal with the third last and the last point before Selina takes over to deal with the escalating claims, and so that in the interest of time, we can get through this quicker. Look, a lot of times in this case, prevention is better than cure. So try not to allow, when you find yourself in a situation that might be a bit tricky or sensitive, try not to allow it to fester before it gets escalated to your legal or insurance teams. I give you a simple example. today you might be dealing with the confidential data of a passenger, and you might not be so familiar with how the data protection regime in your country works, and you would then be asked to maybe share that data with some external third party. Red flags or alarm bells should already be ringing. Of course, find a way to satisfy yourself that what you're doing is compliant. But if you're not sure, I think the advice is find out and ask, right? And then there's no harm. I think your legal team would agree. There's no harm in escalating some of these situations so that it can be cured before a problem arises. And even when you're dealing with passengers and you're communicating with them, well, look, it's difficult to prescribe to you how exactly you should act. And to be fair, every situation and every passenger is different. They could be throwing you a different problem all the time, and that's why y'all are the experts in this field of dealing with situations like that are uncertain on the ground. But as far as possible, what you want to try to ensure is that the amateurs in your position is always protected. That doesn't mean that you can't be diplomatic or you can't be polite, but what it means is that don't give away information unnecessarily. Don't admit to your liability. And we've seen instances where sometimes on the ground, in haste, when there's so much of pressure put by the passenger, you might have the station manager saying, yes, I'm sorry, we are entirely liable, and I'll try and find a way to compensate you. What we don't want is, because the facts may not have been investigated fully yet. Or what if the facts might show that the passenger was at fault in some way? And you don't want to find ourselves in a situation where we have no choice but to settle a case because we've admitted liability at the start, right? And over to Selena on escalating complaints.
Okay, so for complaints, okay, we have seen cases where the station has, not in Malaysian Airlines, but with other carriers, okay, they're not aware that they have received court papers. So, the papers are on their desk for a prolonged period of time, and then later on they found out that, oh, they have missed certain court deadlines. So that would be very, very detrimental. In some jurisdictions, the courts can enter into default judgment, i.e. ruling that, oh, the airline doesn't have any defense, and so the airline is liable for whatever is claimed by the passenger. Now, you don't want to end up in this situation. So I would urge you, whenever you receive a court claim or, any, customer complaint conveyed to regulators, for example, forward them immediately, escalate them immediately to your legal team or your insurance team, and they will ensure that they are handled properly. And another point I would like to add to privileged information is that I've also seen airline staff, again, not Malaysian Airlines, but I've also seen airline staff, they, when communicating with the passengers, okay, about certain claims processes, they inadvertently forwarded advice from their lawyers or from their in-house legal team on the airline's position of liability. The advice essentially says, yes, the airline is liable and we have been doing it wrong and we have to compensate the passenger, etc., etc. That advice was not meant to be circulated to the passenger, but that was forwarded to the passenger inadvertently. So what I encourage you to do is that, when you send an email to external parties or to the passengers, check whether, the contents below your email, whether you have been forwarding something that is not meant for the passenger. Because in law, if the claim is escalated to court, when you have disclosed that piece of information to the passenger, that piece of information is no longer confidential, and the passenger may be able to use that information to the disadvantage of the carrier. So that's what I wanted to add.
Yeah, thanks, Selena. And
Thanks.
we've come to the end of our presentation. I hope that you have taken something away from it, and that practically it will assist you when you're dealing with your next passenger claims. Although in the same breath, I hope that there are not as many passenger claims and they fall. I'll leave Terence to conclude, but thank you for giving us your attention.
Thank you, Manoj and Salina. Shafiq, do we still have a minute?
Yes. Proceed. Just a few minutes.
Okay, be short. I think that brings us to the end of our session today. I think as Manoj and Salina have said, we hope the discussion has been helpful in clarifying how the relevant legal regimes apply in practice, and more importantly, how these frameworks intersect with the realities you face on the ground as station managers. Thank you for your engagement and your thoughtful questions. Dealing with passenger claims, I think I've seen some airlines that have a guidance note to the station managers. The note actually sets out legal framework, commonly asked questions and answers, specific points peculiar to a jurisdiction, and how you should respond to those questions, because it depends on the airline profile. Like we're talking about premium flag carrier, and your response will be different from budget carrier, and also depends on jurisdictions like in certain North Asia countries. And certainly the answers, although the legal regime might be the same or similar, and you may have to adjust your answers accordingly. We're happy to work with you or your legal if required. Should any issues or questions arise following today's discussion, or you require any support on specific passenger claims or regulatory matters, feel free to contact us. Thank you once again for your time and attention. Ini bulan yang amat mulia. On behalf of my team, selamat berpuasa dan selamat Hari Raya in advance.
All right, thank you so much, Terence, Manoj, and Salina, for a very wonderful insight on passenger claims and liability matters. So I hope that participants today will can apply the operational scenarios based on the legal framework and also jurisdiction that have been shared by the speakers today. I think this concludes our first session. Thank you very much. I would say it is a very informative to all of us on this particular issue. So to respect everyone's time, thank you, Pratt & Co. We will proceed with the second session, which, as I mentioned earlier, on the perspective on Indian litigation presented by Legal Knights. So without further ado, I would like to invite Mr. Anurag to proceed with the second session. Thank you very much. Thank you, Salina. Thank you, Manoj. Thank you, Terence.
Thank you.
Thank you. We'll drop out. Thanks. Bye.
Thank you. Bye.
Thank you. Bye.
Thank you. Bye.
Thank you.